So you need to sort out your property because you're getting divorced. Today's episode is going to be about future needs, something that people don't realize is a factor when considering how to divide your property up. Welcome, Mum.
Hello, Laura. Hi, everyone.
Now, before we get started, we're just going to say this blanket cover again, that this is just legal education. We're talking about the Family Law Act. We're talking about a particular section in the Act so that you understand that there are some things that you might not have thought of, but we are not giving legal advice. You should always see a lawyer as each situation is different. And as you will learn from these future need factors, there are a multitude of things that need to be considered. So before we get started, let's go to the jingle.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So, Mum, we did a future needs episode many, many years ago. In fact, I think it was one of our first or second or third episodes, and might have even been the one where the owl flew through the window. So if anyone wants to go to that, please go do, but please listen to it with empathy because we were learning back then. But it is a well listened to one. So I thought we should probably do an updated one. So, Mum, people going through property settlement, most people think about, well, I brought this in, I already owned this house, or I made all this money, or I've got this much super, so I should get this much. But there's an element that people don't think about, isn't there?
Yeah, and it's the future needs element, so that the court has a few steps that they do. And once they've worked out what the property pool is, they work about what the contributions are, then they go to this next step of crystal ball gazing into the future.
And the future needs are of who?
Oh, of the people whose property settlement and maintenance is under consideration. So it is looking forward and saying, if we divide the property based on contributions alone, how will these people be 10 years down the track?
Right. And so it makes slight adjustments based on these factors. Where do people find these list of future needs that we're about to go through? Where do you find it?
For the time being, they're in Section 75(2) of the Family Law Act, and a corresponding section in de facto needs in Section 90 of the Family Law Act. But I've always been learning off the 75(2).
So when it comes to future needs, there is a whole list with does it matter if it's de facto or marriage? You've just discussed that.
No, they're both, yeah. 75(2) applies to marriages, but there is a corresponding section in Section 90 for de facto relationships. Yeah.
Does it make a difference if you had a long or a short marriage, or long or short de facto?
In one of the factors in 75(2) is the length of the marriage and the extent to which it limited your ability to work in the workforce.
Right. So that is a factor, and we will get into that later. Yep. Okay. So we're going to talk about what each one of them are, and then why does it matter? When does it matter? And then we're going to talk about the divorce personality types at the end, like we like to do, and how that may affect the future needs, looking at if you go to court. Yep. If you don't go to court, do you still need to look at these future needs?
Do you mean if you reach a consent order?
If you go to mediation, or if you're just organising it between yourself, should you still consider these future needs?
Yep. It's a vital step in the process, because without considering the future, the court can't make an order that is in just and equitable arrangement. You work out the property pool on a day, on an arbitrary day. Oh, this is what's in the bank. This is what this is worth. And you divide it like that. But they do have to look at the surrounding circumstances and cast their eye further on. And it's in the Family Law Act that they should.
Okay. All right. Well, let's get into number one. What's number one of the future needs?
Age and state of health of the parties. That's the first thing.
Okay.
So if you're both of the same age and you're both of the same health, then there probably isn't an adjustment available for you under that section. But if one of you is much older and therefore got a shorter working life, or one of you has a disease or something that limits you in your future working life, then the contributions-based decision, which might have even come out at 50-50, will be adjusted up a little bit for the person who needs the extra support and their corresponding drop in the other person's side. So typically 5 or 10% if there's an age difference like that.
When it comes to the health, how much proof is needed? Like in mediation, I guess you're convincing your ex, but in court, you're convincing the court. How do you prove your health to someone?
Well, normally with doctor's certificates, or if it's a mental health issue, you might have gone to a psychiatrist, agreed on by the parties to put forward your case.
Mm-hmm.
Yeah, so usually stuff like that. And the importance of it is on your capacity to earn going forward. And also, do you need more medical things? Do you need more surgery going forward? Are you going to need to renovate the house to accommodate a wheelchair, for instance, in the foreseeable future?
Right. So can it be things that you're predisposed to? So you know how people get genetic testing for breast cancer?
Yes.
Can you have that as a future need even though you haven't got breast cancer?
Yeah, no. I think the court won't go into kind of potential claims because that can happen to either of you. Someone might get cancer. Someone might get hit by a car. So the court deals in realities and reasonable projections of what might happen.
Is there ever a chance for an ex to pretend that they have some sort of issue that stops them from working?
Yeah, that often comes up. But unless they can establish it with independent evidence, it may not be agreed and it may not be followed by the court. The onus is on them to prove it.
Okay. If they're closer to, and I know this is quite macabre, but if they're closer to death, like if they're in their late 90s, does that affect? Because you're saying if they can't work anymore because they're too old to work, then they might get an adjustment in their favour. But if they're that old, they can't work, but also they're close to heaven, like does that get considered?
Yes, it's funny because it hasn't come up very often in the court. I think by the time people are in their mid to late 90s, they're really usually not bothering with divorces and things.
Yeah.
But it's true. It is true because let's just say when we're considering future needs and the age and state of health of people, what if one of the people either was very close to the end of their lives or more frequently has a diagnosis, a prognosis of ill health, and it might be that they need lots of resources to support them. So that might give them an uplift in their percentage. But if the condition is sadly terminal and their life expectancy is reduced, then yes, their future needs are reduced. And so the court makes those adjustments.
Well, that's important to know, especially if anyone is in the grey divorce. If you're interested in learning more about grey divorces, older age, go and listen to our grey divorce episode, Splitting Grey Hairs, I think we called it.
Splitting Silver Hairs, I think it was.
Silver Hairs, sorry, Mum. So that's age and health. What's next?
Any difference in your earning capacities or your property or your other financial resources. It's one category, but it's got those three things in it. So income's easy, okay, earning capacity. If someone's on $500,000 a year and someone's on $100,000 a year, there may be an adjustment because of that.
An adjustment in favour of the person who earns less?
Yes. So it's an interesting thing because the court says we're not here to make you on a level playing field forever. If one person's earning $500,000 and you're earning $100,000, you will get a percentage of the existing assets, but can't expect to be supported and evened up or equalised into the future. And then as for property and financial resources, sometimes one point of it is a financial resource that might not be property for the purposes of the Act. Say you're someone who's a beneficiary of a big trust, but you don't have any say in when you'll get that money. But, whenever you need it, someone will drop $100,000 into your account or pay off your mortgage or something. So that's a financial resource to you, but not property. And then the last one is with property, what property you're getting. This stage is always done after you work out the property pool and after you work out contributions, because the court has to look at the contributions and see how that's going to go going forward. So that number, after contribution. But let's say there was $5 million you got as property settlement, right? You wouldn't really get a consideration into the future for future needs because the court would assume that $5 million properly invested will give you support going forward. So if you get too big a chunk of the property, too much money, you might not qualify and it might just be divided on contributions.
Right.
Yeah.
So it's funny that a lot of people think that earning capacity, I earn more than you, so therefore I should get more of the property pool. And other people who go, well, I've got all my money tied up in a trust, a family trust with my parents, and you're not going to get any of that. So that's not counted. So this is where those adjustments do come in, because we do get a lot of people panicking about these trusts and saying it's not fair. What do I do? And a lot of trolls on social media saying, you can't touch my stuff. It's all in a trust. So all of that can be dealt with through this part of that.
This sort of thing. If they've really successfully got rid of assets into a trust or something and the court can't unpick it, then they can look at what other assets they've got and give you a greater share if you're not the beneficiary.
And it is important to note that the court can usually unpick a trust. It's just
most times.
So don't think that, it's a trust, it's untouchable, because the court has ways. All right. So what are the next ones, Mum?
Okay. So whether you've got a child under the age of 18, and this is where I think a lot of going to be controversial here, but a lot of the times the 50-50 arrangement with kids, with families, meant there was no adjustment whatsoever because you both got the kids 50-50. Before the changes to the law, and the person with whom the child lived most of the time would get an extra 10% or so of the property pool, because they have to provide more, a bigger house over their head. They can't ride around on a motorbike, and they've got kids. They have to put them in a car, all of that sort of stuff. So it used to not be as controversial, but I do think sometimes some of the child orders, because of this, and child support, that they fight.
So you're saying because this is in there as a adjustment in the favour of the person that gets the children, you think there are some people out there who are just going for custody so that doesn't happen?
Yes, and it's not just me. I mean, they were the submissions made to the Australian Law Reform Commission, I think, ARLC, and that's why they are changing the legislation so that doesn't happen as frequently. The next one's not so commonly invoked, but it's if the person has got a responsibility to care for a child under the age of 18, obviously, but not a child of the relationship. So, they might have a look if you become the sole carer or sole parent surviving perhaps of a child of another relationship, that might come into account. It hardly ever gets invoked. And I can't even think of a case about it, but it's there.
Okay.
One of the other tests was a reasonable standard of living, which has begun to be a bit diluted these days. As long as you're not on the breadline, they would not normally make an adjustment if you're working and the other person's working. Really interesting one, impact of the length of the marriage on your capacity to earn. And that's one that comes in a lot, because in a couple, when you're both working in the same direction for something, it might be agreed between you both that you might move from town to town to promote that one person's career. And at the end of it, what's happened is you don't have a big superannuation. You don't have the currency in your job that you need. You might have to update your qualifications. It's a big shock when suddenly you've got to look after yourself and you find they've been achieved a lot and you haven't. So duration of the marriage is important, and the extent to which it's affected your learning capacity. So those things I talked about, they're the things you would put in an affidavit to say about it.
So let's, for example, it would be like, I quit my job. I was in a promising position to climb the corporate ladder. I quit my job to support my ex in doing whatever they did and lost my opportunity to become a partner of the practice or whatever. And that's not fair. That's
right.
That's a second consideration. How often do you see that happening?
Yeah. Oh, pretty often. Okay. You'll find, I see it a lot in military and mining workers. And the next one's sort of on the same vein, and that is the extent to which the person whose maintenance is under consideration has contributed to and contributed to the other person's high earning capacity, great income. So it sounds very hard, but imagine, and I've had this case about 25 years ago, someone came to me, you worked a job, you raised the children, the other parent was working as studying medicine, all the hours God gave them, and then finally they get through and then they leave the marriage.
Oh, that would be so upsetting.
Yes. And so they're on $250,000, $500,000 a year. You haven't worked for 15 years or so. You've been home with the kids and damn.
Right.
And so the court does look at that, and that comes up quite a lot. And they consider that you contributed to them being able to make that earning capacity. Otherwise, they would have had to mind the kids and earn money to live on. So that's quite a prominent one that happens.
What about people that are told by their exes they have to quit their job? And I get this question a lot.
Yeah.
And my ex made me quit my job and made me be the stay-at-home mum, promising to support me. And some of them's really there's coercive control, like red flags all over the place.
Yes,
because they quit their job, then they had no money to their name. They were given a card. They could spend that on groceries and the kids, and that's it. You know.
Yeah, and you get quizzed. What did you buy there, and why were you there with your card?
So that kind of contributing to them earning, is that looked at in that kind of light?
Yeah, it comes up. It's raised in that thing.
Okay,
but it isn't as persuasive as you'd think, because the court assumes that the marriage has what they call a traditional role, with one going out to work and a stay-at-home mum. They assume that happened with the consent of both parties. And therefore that was how you arranged your marriage. And the impacts of that should be shared or should be catered for at the end of the relationship. Okay, and if a person forced you to give up your job, I don't think that sways the court that much, because it was in the marriage. It was obviously agreed on at some level, and the court doesn't go back picking over the old ashes of a relationship like that. But people get really angry that they were forced to quit their jobs. And if my client said that had happened, I would always mention that.
Yeah.
And it may have some validity going forward when the court starts looking at coercive control more in a financial relationship. And it might be one of the factors that can demonstrate it.
They're currently trying to come up with a national definition of coercive control. They're actually negotiating now. So it will be interesting to see if they get it right or if they miss the mark in our eyes anyway. All right. So we've got age, health, earning capacity, children under 18, responsibility for another child, reasonable standard of living, length of the marriage, contributed to their earning capacity. What else?
Well, oddly, there's one here about the financial circumstances of a person who is in a de facto relationship. And that's a bit out of fashion now. But if you were in a new relationship with someone who is a multimillionaire, then in the old days, the court would say, well, you're going to get married again, so you don't need as much. You've got a new relationship. I know. But really what 75(2) is involved in is actually, it's a hybrid section of the Act. Okay, so we're reading it as part of the property settlement, but actually it's mainly for spousal maintenance. So any extra percent you get for future needs, it's like lump sum spousal maintenance. And in spousal maintenance, the financial circumstances of living with someone else is relevant if you're looking for a week-to-week payment and you've got someone else who can pay half the bills. So it's really kind of shouldn't be in there for the lump sum thing. And the court very quickly jumped on a judge who said, oh, you're an attractive young woman, you'll get married again.
What year was that? What year?
Late 70s.
Oh, okay.
Late 70s. We've come a long way.
I hope so. Okay. All right. So that one, they kind of don't really look at that anymore.
Not really.
What else?
They look at what property, I think I talked to that, what property you are getting in that property settlement.
Yep.
And then any child support you're going to receive or not. So if you've got someone who isn't paying their child support and you've got the kids more often than not, you can get an adjustment for that because the record shows they were late or patchy with paying child support. So the court can give you an adjustment in that. So it's a weird crossover, isn't it?
So you could say, here's a screenshot of the child support app and this is how much they're in arrears, or this is how often they were in arrears. I couldn't rely on child support for anything because I never knew when it was coming. So can I rely on the 75(2) factors of the family court future needs, can you adjust it slightly? Because this person's definitely not going to be paying child support in the future.
Yeah, and the court's really good. Sometimes you'll find a person will pay their child support arrears the day before you go to court or 2 days before you go to court, and they do it all the way through the court proceedings. I've seen successful arguments about that, saying, look, this bloke is, or usually bloke, never going to pay unless you're actually going to court. So past behaviour is the best indicator of future behaviour. Give me a lump sum, and if he pays child support on top of that, good, but I'm not relying on it.
So because they give an adjustment because that person is being a bozo and not paying child support, doesn't mean that they're still not going to be in arrears for child support. They'll still have to keep paying it. It's just that it might not come. That's good. That's a big cautionary tale to anybody who wants to hold back paying child support if you're going through property settlement. That's cautionary tale. All right, what's next, Mum?
We're getting close to the end. This one is the every player wins a prize one, 7520, and it just says, any other circumstance that the justice of the case requires to be taken into account.
Okay. So just anything else?
Anything. So examples, someone had written a book, had a deal with a book company to finish writing the book, but there was no money yet available, and it all depended on the person finishing the book and distributing the book. So that might be very pie in the sky, and there might be a minor adjustment for that. Or a person might be a successful author and there's a book in the pipeline and they've got royalties coming in from these books, but it's not actually property and it's not, strictly speaking, income because it's royalties. So all of that. So it just gives a lot of leeway for the court to work out what's fair, because overall they have to make a decision that is just and equitable in relation to both parties.
So when you say this, how much percentage, like a minor adjustment, like you've listed a lot of things: age, health, earning capacity, financial resources, property in your name, children under 18, responsibility, all of these things. If you got an adjustment of, say, 5% for each one, 5, 10, 15, 20, 25, 30, 35, 40, 45, like you could end up with 100% of the property pool. Does that ever happen?
Well, no, they don't do that. On future needs, they would also have to look at the other person's financial circumstances going forward.
Right.
Okay.
So you balance each other out sometimes.
Yeah, that's right. So often what happens is only 3 or 4 or 2 of those factors apply in any one particular case. And sometimes there's a factor on one side, say they're older than our client, and the woman is older than our client and hasn't got as long to work. So there might be a bolstering of their share. But then say you've got all the kids in your care. So when yours goes up, theirs goes down a bit. And what the law is, what the cases say, is that the percentages vary, like whether it's a 1% adjustment for something or a 5 or a 10%, varies on what its real impact is. So if you've got a small property pool, every 10%, say you've got $100,000 property pool, right? So every 1% is $1,000. Every 10% is $10,000. So a 10% adjustment for having the care of the children, or because you've contributed to someone else's earning capacity on a $100,000 pool, is only $10,000, and it's chicken feed, isn't it? So the court would probably look at a bigger adjustment on a small pool so that it's in real terms, not just in percentage. But then the other thing, if you're talking a $20 million property pool, then the adjustments would be maybe small, maybe 1%, because that still gives a person a significant payout.
Or 1% of $20 million is a lot of money, as opposed to 1% of $100, which is hardly anything.
Yes.
Okay, I see. So they adjust it based on the size of the pool as to how big a percentage they'd move things around.
Right. So you can see, can't you, the discretion that a judge has in this area with property settlements, and it's why you might go to 2 different lawyers, your lawyer, their lawyer, and they have a different view about what the outcome might be. And it might even be that one judge would give a different amount to another judge. They're just doing the best they can, and they look at the people in the witness boxes, and it depends how well your case is presented and how well you shape up in the witness box. It's just a lot of things. And there's a range, and it's usually about 10% or so.
Have you seen people try and be dishonest about these things too?
Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today.
Have you seen people try and be dishonest about these things too?
Oh, you think?
Or is there a playbook of the manipulative and controlling narcissistic types when it comes to future needs?
Okay. Well, apart from the kids, fighting really hard to have 50-50 with the kids, if it's their motive, I'm not saying everyone's like this, but if it's the motive for money, that might be it. I've seen people whose partners just gave up their job and said, I'm not earning anymore, so therefore I've got the same future needs as you have. I don't have that big salary anymore. The bad news is that Section 75(2) and the other section for de factos talks about capacity to earn, not your actual earning. So if a person's throwing their job in, hoping to influence the property settlement, it probably won't do them any good because everyone knows they can just go back and get the job afterwards.
So those horrible humans that quit their job and say, I can't pay for anything, even though they were earning like $500,000 a year, that doesn't fly with the court.
It doesn't. The court is very suspicious and they'd have to prove why they aren't working. And, you know, people who do those sorts of things, they'll try nearly everything. Oh, I've got to look after my new partner's child, my stepdaughter, my stepson, or I've got to care for my mother, or what. They do a lot of tweaking of everything to try and minimize the adjustment. And it becomes a pattern. You can see it. It becomes a pattern. Oh, I've stopped working overtime now, or I haven't signed a new contract for ages. That's another way of lowering the cost of it. Or my ex could get a job. Look at all these jobs she could get. And then, or they might deny that it was a family arrangement for one person to stay home and one person to go. They might say they were the primary carers of the children when they weren't. Just trying to tweak all those things in their direction. Yeah.
But I guess that's something to be mindful of if you are going through your property settlement or just the divorce in the start, that these things will be looked at and considered. And if you've got a manipulative, controlling ex, be mindful of them trying to, if they've got their legal advice and now they're trying to tweak things so that these factors work in their favour, just be aware of it. Mum, when it comes to avoidant, do you have people who just are like, I don't care about future needs. I just want to be fair. I just want to do the right thing by my ex. I don't want to rip them off. I don't feel like I'm entitled. Do you have people who just avoid these factors and don't want to talk about them or look at them?
Yeah, you do from time to time, especially if the pool's quite modest and if the other person is taking it very hard, like if there's a risk of mental health or perhaps if there's a risk of family violence to you. Now, if the property pool's small, as we discussed, if it's $100,000, we're talking maybe $10,000, right? Or something. And it might not be worth fighting all the way to a trial just for an extra $10,000. So sometimes that's within the range where someone will go, look, I don't want the expense or the delay or the uncertainty of this. I just want out. And you could explain that to a judge and consent orders will come through. I think the court would understand that argument. They frequently have. But when there's a lot of money involved and the person says, oh, they had that when we got together, or I don't feel that sort of thing, you really, like when I was practicing, you really have to write a very clear letter about what it is they're giving up by not doing anything. Another sort of thing is where someone is that they've worked out between themselves the property settlement based on contributions, but then the other person says to the person who doesn't have the income or big income, I'll always look after you. I'm going to pay this. I'm going to pay your rent. I'm going to put the kids through school and all of that. But if you ask for any more in the property settlement, then you're getting none of that. You're on your own. And so people get very scared to put pen to paper to ask for it in their own right. But I think it's a coercive or financial controlling thing. And I think that when they do pay for your rent, I've seen so many times where they actually choose where you live and the mortgage is the lease is in their own name. And it is a way of keeping control of you without giving you the money. They might say, oh, she's no good with money. I'm not giving her any money. She can't manage. Just stupid things like that. Mm-hmm. But yes, so it is a kind of manipulation by those sort of people, and that so often the weaker party can't afford to go anywhere else for fear that this will cut off.
Mm. I guess it's important to mention the triple P 500 here. If you are thinking that it's going to end up in court, you can go into this program where it's anything, and the property pool is under $500,000. And maybe that will be more helpful for those types of people.
Yeah, I think nearly every registry has those now. Yeah. So what the court has identified is these ones shouldn't take the same complex pathway as cases with millions of dollars and trusts and things. So they're trying to get like an express lane. I think I described it at Coles to get you out and done quickly, so that because if you've got a $100,000 property pool and you're going to spend $50,000 each in going to court, so you might as well let the other person have the whole $100,000, which isn't fair. Mm-hmm. So what the court has done is tried to shorten how long that case would take and how expensive that case would be.
When it comes to high conflict, obviously that's going to be a big nightmare, because you say, oh, I think I should get a little bit more because, I don't know, I contributed to you becoming a doctor. And they're like, no, you didn't. Like, does it just end up in an affidavit, he said, she said drama, or?
Kind of, yeah, pretty well. I mean, I think life's going to be a lot easier for everyone in the court now that we have Facebook and text messages and all of that. And it might take something like, I can't come home tonight, I've got this assignment to do, or something like that. I'm not cooking tea. So, but until that happens, we really have like common sense. So judge has to look at that and go, how likely is it that a man with 3 toddlers would have been able to study and pass his medical unless the other person was helping, so they can turn their life experience to it. But yeah, they slug it out on pretty well every point. And you do have to pick your battles. And the reason they slug this out, like the future needs, is because contributions can be proven. You can pretty well establish everything that came into a relationship. But what happens in the relationship is not apparent to everyone. And I don't think people are in a relationship thinking they're going to get out of it. I don't think they start down that path thinking, I better get my evidence ready for when I go.
Yeah. Well, you've got receipts for buying a house. You've got receipts for putting money in a trust account or whatever. You don't have receipts for how many late nights you spent up looking after the kids by yourselves while they vomited in the loo while your ex was studying somewhere. You don't have those receipts unless you documented your life on Facebook to the nth degree. And yes, look at my bag, you might say.
Look at my face.
They have my receipts, but it's tough. It's a tough industry to be in, to be like, how much is that worth? How much of that hard sweat and tears of my life is that worth in dollar value?
Yeah.
It's a rough industry.
When the Family Law Act was written, it was traditional for a person when they get married to leave the workforce. A woman would leave the workforce. I did it, 1974, out of the job. I'd only worked part-time from then on, having babies and so forth. And I remember one of my first clients ever was the wife of a bank manager, and she was in her early 70s or late 60s. And she was so distraught. She didn't even know anything about their finances or how to write a check, which we used in that. She just was absolutely frozen. But her contribution to this country town bank manager was that she entertained people. She went out with him to functions. She kept the house they were constantly being visited. And her role was a bit like
marketer.
Bewitched. Samantha.
Oh, Bewitched, yeah.
And Darren. Samantha,
hosted all the parties and educate,
Absolutely.
Entertain.
Absolutely. And so you can understand that her component for future needs would have been massive, and also her contribution to the career of the person. would have been massive. So, but these days, they're slightly different contributions. And it's hard because sometimes someone will say, well, you should have worked as well. But Mallet's case says, no, if you're staying at home to care for the children, that's a legitimate use of your time.
Look, I hate giving voices to these trolls that we get messages from all the time, but that's one of their arguments. They're like, oh, well, if she wants money, then she should get a job. And, but then you're like, but they were looking after the children. What were you doing? And like, just the whole headspace around that is, I think Australia and America have a long way to go to respect the work that is done by a stay-at-home parent. But on the flip side of that, Mum, I've noticed there is a problem with this newish. When it came in 75.
The Family Law Act, 1975.
1975. Yeah. So nowadays, you can be a high-paid, high-educated working woman and also be the primary carer of the children. And I know you said, show me someone who's got this medical degree and someone didn't look after the toddlers, but I've seen people do that. They do the whole thing themselves while their partner doesn't. It doesn't account for it.
Well, it's the women who get the maternity leave. And so it is usually the women who take on that primary role with the children. And I mean, I did it all, but it was exhausting. And it is very hard. Just because we can do it doesn't mean we should be doing it. And is that in the best interests of our children?
I get that, but there's no accounting for it. We've done an episode called Gold Diggers, and it's a twist where it's and we have so many of these ladies writing into us. They're, wealthy doctors working their butts off, looking after the kids, juggling everything, and their ex is just sitting on the couch playing PlayStation, and that's all they do. And then there comes to property settlement, and then the ex is saying, oh, well, you were the doctor, I was the stay-at-home primary carer, when they had nothing to do with the kids. So there is that element. If you are in that situation, because I know we've done episodes before and I could hear you screaming through the emails at us, we have an episode for you called Gold Diggers, which is a twist on the old type of gold digger. Go and listen to that episode, and I'll put that link in the show notes. But I do feel like there's no accommodating for that. The court seems to assume that if you're the primary breadwinner, you're not the primary carer.
Yes. Well, I don't know that dichotomy will last much longer. Hopefully. I think as time goes by, it will get more common to adjust that. But I guess if you're looking at the benefit to a person who's done all that and minded the kids, when you're looking at future, even if, so they don't adjust to the other parent if they don't no longer have the care of a child. It's only adjust if they may have or do have care of a child. But going forward, this person who's done all that hard work will have the benefit of that income long into the future, way past child support considerations, and there's some compensation there. And I think you have to think about this, that what happens in a marriage, even if you are too busy to sort of bail on a relationship, but what happens in the relationship is assumed to have been happening with the permission, at least without the other person complaining. You can see it, you haven't left, so you must like it.
And it's a terrible assumption. Some people are stuck in there and they can't get out.
That's a word we hear all the time. I'm stuck.
Yeah.
I can't afford to move out. And the other person holds all the swords.
Won't let me. If you are in that situation, please go listen to our Gilded Cage episode or some of our coercive control episodes. 4 things you might not realize are coercive control. Now, when it comes to amicable mum and talking about future needs for property settlement, I can see it in my head. I've never seen it in real life, where 2 people sit down at a table together and go, okay, here's all our property. This is what our asset pool is. Let's break it up. And you have this much and I'll have this much. And then let's look at these future needs. Oh, because of future needs, I'm going to get 60 to 65% and you just get the little bit left. Is there ever an amicable situation where that works, or does talking about these factors break up the chance of amicable?
I don't know. It depends the size of the property pool. If it's a little $10,000 here or there, no. Sometimes people are offended when they are told that the other person is going to have the child more often than they are, then that's like saying to them, you're not a good parent because I'm going to be more of a parent than you. It's that sort of thing. But I'm sure I don't see them, Laura. I'm sure that the ones who can work it out, do work it out.
Yeah.
Then they either do consent orders themselves or they go and see a lawyer to do the consent orders.
So you never see it was amicable, but we were talking about future needs and it's all fallen apart.
Oh, I used to see many people who started out amicable until my client made a reasonable request and they said no. Or the other person thought they had them under control and then my client said no and it all blew up. But that's like flushing out the narcissistic types who are acting as amicable.
Everything will be good and everything will be fine as long as you say yes. And so we've got an episode called When Amicable Goes Wrong, and that might be a really good one. If you search deep in your heart and think, if I bring up these factors with my amicable ex to say I probably should get an adjustment in my favour, if you're afraid to bring that up, then you need to go listen to that episode because it might not be amicable. It might be amicable in narcissistic clothing. No, narcissists in amicable clothing.
And another way, if you're negotiating, and we talk about this in our course, Laura, if you're negotiating percentages, knowing what you are wanting the extra percentages for is one thing. What you tell the other party the adjustments for is another thing. So it doesn't matter what they call it, doesn't matter what you call it if you get to the right number. So you might say, you might know all of these factors. You think I've got at least 10% adjustment on all of those things. But I'll just say 15% because of our income capacity. Yeah. And that's more palatable. So, yes. So in your negotiations, you might not go, and you're not going to live as long as I am, so I'll have that. And leave that to the lawyers to be awful about.
So what you're saying is repackage, go and look at the numbers. If you're doing our course, you go and do the property module, figure out your asset pool, look at the contributions, do the worksheet, and then look at these future needs and then do that worksheet. But you're saying you don't show that worksheet to your ex. You repackage it in a nicer way. So it's like marketing.
Yeah, it is. It's persuasion. Lawyers are persuaders. We persuade the court, hopefully. And you're persuading your ex to see this as a reasonable offer. Sometimes, if there's a very high conflict person on the other side in a mediation, I would just get the client to write down a dot with a number on it, right? And I'd take that over and it would be just a sort of a bargaining exercise. And then my client would say, well, I'm happy with that because I think my contribution was, say, 45 and this is my future. I'm happy with that. And in the other room, they're going, at least she didn't get an adjustment for what's that? Yes. If you present all of your 75-2 factors with the individual adjustments for each one, which the court says you mustn't anyway, you run the risk of someone beating each one of them down by 1 or 2%. And then when they should be talking numbers, they can't get over the fact that you dared to say that you minded the kids or you dared to say that they told you to stop work. Like that. Because what it does, it transports everyone back into the marriage to have the fight that they've always been having.
Right.
You know? So if you were splitting toys up in a preschool or something, you wouldn't say, let's give this to Tommy because you were so awful yesterday. You'd just say, how about we give this one to Tommy and I'll give you this car, you know.
So, Mum, can I ask you a question? And we've got to wrap it up, but you mentioned that the court says not to list the factors and the percentages, but don't you have to argue that in court? Aren't you supposed to put that across?
Yes, so you argue each of those things, right? But the court is taking them into account just in the overall framework of contributions and the future needs. And it's like you put it all in, mix it up, and out comes a number. And they don't normally have to say what component of that is for spousal maintenance, lump sum spousal maintenance.
But that's how they would get to that number.
Oh, yes. But like I said, someone will go up. It's like a seesaw, right? Yeah. I'm not well, so I should get more, but you don't earn as much, so you should get a bit more. And it just depends where it ends up. There's no doubt that's why the court representation of justice is scales with a blindfold on.
And if you were in front of 4 different judges, you might get 4 slightly different.
Slightly different.
By
Absolutely.
10%, 20%
Yep.
different.
Yep.
Okay.
Yep. So your case, to get your big amount, the full amount, you're going to have a bright, shiny day in court where nothing goes wrong. And it might go wrong,
Okay. Well, if you're listening to this, hopefully you don't have to go to court. Hopefully you can negotiate in mediation or sit around the coffee table with your amicable person. Mum, thank you for doing this episode. Are there any cases that are linked to this that are any good?
Yeah. So there's Clausen, Clauson. Mallett's case talks about the importance of a parenting contribution and the length of a marriage. Yeah. They're the 2 probably leading cases. Walters and Jurek as well.
So if you're interested in any of those, I think Mallett's is already up.
I've done Mallett's, yes.
Patreon, but Mum might do Clausen's for us for this one. If you're interested, you can go check it out in Patreon. But if you are going through this, guys, it does seem like some sort of magical calculator that no one can see in the sky. But like Mum said, it's more about presenting it in a way that people aren't going to fight over it. So it's not just numbers. It's also being persuasive and thinking about the type of ex you have and what's going to work and what's not. But we wish you all the best.
We do.
And hopefully, if you're interested in any of the other property episodes, go and listen to those. They're quite early in the podcast era, but we will revisit them shortly soon as well. Okay. Right. Thank you so much, Mum, for your time.
No worries, Laura. Bye.
Okay.
Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording